really simmer it down, those are the only four tools. For purposes of today's discussion, I'm going to add privacy rights, just because they often tend to be. It isn't technically an intellectual property right. It's a privacy right from the Constitution, but it is often closely intertwined, particularly with copyright issues. So I wanted to include it. Um, so I'm going to jump in. So this is going to go in reverse order. I'm going to go with the tools that you're probably going to encounter the least in the context of a faith-based nonprofit, and go to the tools that you're going to probably encounter the most often. So a patent is the right to prevent others from using an invention, and you get that right for a limited period of time. So you get a monopoly for a limited period of time in exchange for public disclosure of your invention. So that's the bargain with the public that you get when you seek patent protection. And just sort of our fun fact for the day is it's actually in the Constitution. So I have job security. So it's Congress is authorized to set up the patent system to protect the rights of inventors for the inventions that they create. So like I said, a little job security there. And that's really, I was serious about it. It's really all I'm going to say about it, because my sense is that for most faith-based nonprofits, this is something you're just not going to come in contact with. But I wanted to at least mention it for sake of thoroughness. Trade secrets. Um, Trade secrets are business information that isn't publicly available, and it has to be subject to reasonable efforts to maintain its secrecy. So there's three requirements there. One is it has to be business information, can't just be personal information. It can't be publicly available. So if you can go out and get that information as a member of the public, it's not a trade secret. And then you have to have reasonable efforts to maintain the secrecy of that information. So let's get a little more a little more secret here. So, you know, classic trade secret for well over 100 years. Nobody knows exactly how this stuff is made. Why? Because it's not, the information isn't publicly available. It's not easily reverse engineerable, and they have made efforts to maintain its secrecy. Do some internet searching on this. It's kind of an interesting topic of how people have tried and failed and some of the scandals that have come around people trying to disclose how this trade secret or how this product's made. So in general, in the business world, trade secrets are fall into a bunch of different categories, but here are some of the most common ones. So you have recipes and chemical formulas, you have business methods and strategies, you have some computer software, you have manufacturing methods. That's a big one, where you have how companies make things, inside the four walls of the company, and collections of data. And so let's tailor that a little bit to faith-based nonprofits. Where are your trade secrets? Well, your donor lists and your giving histories and your fundraising strategies are typically, and when you're going to talk most common and high value, that's where your trade secrets are coming from. And then you may also have other areas where you may have operational procedures. You may have marketing and branding strategies, grant strategies, how you go about choosing the grants you pursue, how you obtain those grants, your grant writing skills and methods, things like that. And if you happen to have custom built software, this is typically something for larger organizations, but all of these things can be trade secrets. So how do we deal with these? And this is going to be you're going to see this for almost every tool. So what's the first thing you're doing? Well, you need to identify what are your trade secrets. It's going to be a little different for each organization, but for many of you, that's going to be your donor information. It may also be your client information. If you are a public facing service organization where you're serving members of the public, you may collect information about them. That it may be, again, your grant writing strategy. All of those things can be trade secrets. So step one in terms of managing this is make a list. Just sit down and make a list of everything that might be a trade secret. And then you need to take reasonable steps to maintain its secrecy. So what does that mean? That means having written non-disclosure agreements with the people who come in contact with those trade secrets. So employees, contractors, and don't forget your volunteers. Um, if they come in contact with that trade secret information, if you want to maintain it as a trade secret, you've really got to have a written non-disclosure agreement. If you don't, in most cases, that's going to be deemed not taking reasonable steps to maintain secrecy. Um, Security is the other piece of it. And these aren't, it doesn't have to be Fort Knox, but reasonable efforts to maintain security, having passwords, to access network drives if it's electronically stored information, um, locking doors when no one's there. Simple logical things, but if you don't think about it and take those reasonable steps, it's easy to leave yourselves vulnerable. Um, Labeling things that are confidential so that people know that there's confidential information, restricting who has access to it. So maybe if you have a network drive with files, maybe you're not giving everyone in your organization access to a particular drive that has the trade secret information on it. And then that's cybersecurity, which sort of is just taking the two-factor authentication is now is kind of becoming the standard. So you're looking at having those agreements to have people have the obligation, a contractual obligation to keep the information secret, and then having the security in place to not have an accidental release of trade secret information simply because you're not taking reasonable measures to keep it secret. All right. My first little, I'll call this a little side quest. There are going to be a few of those today where what dovetails with this is you're talking about donor information, you're talking about um, giving information. Make sure that you're paying attention to regulations relating to personally identifiable information. Every state's got them now. Personally identifiable information is people's names, their home address, things that are more sensitive. You get into birth dates, social security numbers, credit card information. Um, Based on my experience in dealing with faith-based nonprofit, most of the personally identifiable information is there are tiers, and so there are different regulations for how sensitive the information is, with like a social security number being the most sensitive, and or a credit card number being the most sensitive, a person's name and their home address being less sensitive. In most cases, my experience has been that the faith-based nonprofits, you've got people's names and addresses. You might have a birth date so that you can contact them for outreach. But for the most part, you're using third-party providers for credit card information, and you're not holding on to people's social security numbers. So that's a good thing because you're not at that top tier. I could spend an hour just talking about this. That's why I'm calling it a little side quest, but be aware of it. And the idea there is that you also have to have reasonable measures to prevent an unauthorized data breach for the personally identifiable information. And if you have a breach, you have to have a process in place for notifying the people whose data has been released in an unauthorized way. Like I said, I could spend a half an hour just on this. I want to raise the issue so it's something hopefully that you're paying attention to. All right, let's go to trademarks. Trademarks are a little different than the other tools. So a trademark is a word, design, or expression which identifies a product or service as coming from a particular source. The reason it's different is that its purpose. Other types of intellectual property, the purpose is to provide some sort of protection to the person or persons who created the intellectual property. In the trademark world, its purpose is to prevent consumers from being confused. So it's a little different qualitatively than the other intellectual property tools. So a couple of examples. Everyone knows I think everyone's going to know all these. So this is a classic word mark. That's a trademark. Logos can be a trademark. And the idea here, coming back to this sort of consumer protection thing, is that what you want is you want consumers not to be surprised or be confused. So good or bad, when you walk into a restaurant that's got this logo out front, you know what you're getting. There's a consumer, there's a level of expectation. You recognize, what am I going to get when I go there? And maybe that's a good thing. Maybe you want some nugs, but if you're not going to walk in there expecting it to be a 4-star steakhouse. I like this one because it's interesting. Most folks are going to recognize this too, where the color in connection with insulation. So pink insulation actually is a trademark. It's Owens Corning. And so other companies can't make insulation that's pink, and they've spent years and millions of dollars developing this association. So these are just to give examples of the different things that can function as trademarks. So same playbook. How do you manage trademark rights? Well, you need to identify the marks that you're using, word marks, logos, things that you're using as a brand identifier that's providing a connection between to your organization. Identify what those are, and then for your existing marks, then take appropriate action to protect them. I will also say this a couple times throughout the presentation, which is there's a unique challenge with nonprofits in the sense that you're not in the business of generating revenue from this intellectual property. You're in the business of helping people. And so there are some times when doing something that costs money doesn't make sense, or depending on what it costs. So registering a trademark is something that costs money. It's about $1,500 to file it, depending on how many classes, and probably overall from soup to nuts, a $2,000 to $4,000 project to get a trademark registration. That may not make sense for your organization. You get some trademark rights through using the trademark, but you can get additional protection through seeking a federal registration. It's not always a no-brainer. And for many of your organizations, you may be operating under the umbrella of a parent organization. If you're a division that provides services from a Catholic diocese, the diocese is going to have their own trademarks, and that may not be something that you control. So you have the use and registration side of things. Then it's a good idea, particularly if your organization is of any size, to provide a guide to consistently use the trademarks so that you're not having too many unintentional variations, because that weakens the trademark. So you want to have that trademark be as strong as possible. So this can simply be, hey, when you're going to use our logo, have it look like this, and be consistent about how it's used. If you're going to allow someone else to offer goods or services under your trademark, have a written license. You don't have to charge them money. You can, but you want to have a license because you want the benefit of that use to keep coming to you. If you let someone use your trademark and offer goods and services outside of your organization under your trademark, and you don't have a written license with them, that weakens your trademark. And on a similar vein, if someone else is using it in an unauthorized way, if you don't do any enforcement or policing, that can weaken your trademark as well. And these create challenges, because if a party doesn't want to stop, if they're infringing your trademark and they don't want to stop, litigating that is expensive. I get that. But and all I'm saying is that there is a consequence if you let someone use your mark in an unauthorized way that's an infringement, and you don't do anything about it. So that sometimes can lead to a hard choice. So then let's shift gears to new marks. If you're going to introduce a new trademark, my recommendation is you get some sort of a clearance review to see if there's another similar trademark out there that you might be infringing, or that might make it hard for you to register that trademark. When you do that, check domain names, check social media pages to see if there's availability there as well, because social media and domain names are so intricately a part of how people find us now, that it's important to look at that as well. All right, another little quick side quest, which is just be careful when in your own media, if you are showing someone else's trademark. The hazard there is that if you do it in a way, let's say someone's at one of your fundraisers and they're wearing a polo shirt that's got a corporate logo on it. If that company's not a sponsor or is not somehow affiliated with that event, showing that logo in a photo from that event could imply some sort of endorsement or sponsorship, and they may object. It's just something to pay attention to. If they object, typically no one's going to demand money. Typically the consequence is they just ask you to take it down. So it's not something where if you make this mistake, it's going to, it's going to be an expensive one. Typically it's something that's fairly easy to remedy, but just something to put in the back of your mind when you're seeing those photos. Just be careful about those third-party trademarks that are showing up in images.
Can I ask a question about that? Because I think one of the
Sure.
common ways where nonprofits, especially those who are involved in media, might have this issue is like if, say, a big prominent news organization or magazine writes an article about your organization, right? So in addition to sharing the link to the article, you put the, Fox News logo or whatever it is. Is that like if you put that up on your website, is that something similar to this where you'd be worried about third-party use of a trademark?
This is something else I'm going to say a lot during this presentation. It depends. Um, so if you're using that logo to identify who the story came from, that's one thing. That's okay. That's okay. If you're using it in a way that implies some sort of sponsorship or endorsement, um, that's something else. And this is, in your hypothetical has all sorts of if, ands, or buts, which is how are you linking it? How are you, are you providing a link to their website? Are you embedding the story in yours? Are you doing a screenshot? Like it all matters, unfortunately. um, but just the fact of using their trademark or their logo, it depends on the context. How is it used? If it if a reasonable consumer is going to think that there's an endorsement there or a sponsorship, then that's going to be a problem. And, and honestly, the effect is, what are they going to do? They're going to ask you to take it down. And if you take it down promptly and you don't do it all the time, it's not going to be something that's going to go any further than that.
Great, thank you.
All right. All right. So let's go into the last. This is going to be the biggest section on copyright. So copyright is the legal right to control the use or reproduction of an original work of authorship. All right. So what's an original work of authorship? This is not a complete list, but this is a list of the most common. So literary works, artistic works, photographs and videos. So that's images, movies, television shows, regular videos, music, and software. Those are the biggest. There's architecture is also one. You can have there's actually a special section in the copyright law for boat hulls, but I didn't think that was particularly relevant. These are the ones that we need to be concerned about. So these are what works of authorship are. So I'm also going to preface this section in this is hard. This is complicated. There's lots of nuances, and sophisticated companies screw this up. So about 5 years ago, I don't remember in the news, Peloton, when they were running their videos for when you be on your bike and you got the instructor, what were they doing in the background? They had music running, and they didn't get the public performance licenses for that music. So they got tagged with a $150 million lawsuit because they weren't doing that. Sophisticated companies screw this up. That's the message here. So don't feel bad if you, in fact, I can tell you right now, you're not going to leave this and go, oh, this is easy. I got this. It's complicated and it's nuanced. The idea is to help you issue spot, resolve the easy stuff, and then know when to ask for help. So how do we manage it? For your own copy. So first part is you're going to generate copyrightable subject matter as an organization. People are going to take photos. People are going to write articles. So you want to make sure that your organization owns the copyright to the materials that the people that are working on your behalf generate. So you want to have employment agreements that have IP assignment clauses that mean that the copyright, and that's a little bit of a belt and suspenders because technically an employee in the scope of his or her employment, if they create something copyrightable, the employer owns it. But it's the best practice is to have a clause in your employment agreement. Independent contractors, you've got to have it in there. Because if you have an independent contractor come in and take photos of an event, they own those photos. You get a non-exclusive license to those photos. And if you're okay with that, that's not the end of the world. But if you want exclusive ownership of those photos, then it's got to say so. There's got to be an IP assignment clause in your contract. And don't forget your volunteers. Same in the event that they're generating copyrightable subject matter. Software licensing used to be a real big one. It's, in my view, it's becoming less of an issue because software has moved to this subscription model, and it's much more difficult to accidentally have that same CD installed on 16 different computers. That doesn't really happen anymore, but it is something to pay attention to. You want it because if you don't get this one right, they will come after you, and they will be looking for money. Um, but again, the risk here, in my view, with the software as a service model, the prevalence of that now is much less of an issue. Um, and then when you're using the copyrightable subject matter of others, you need to confirm that you have rights or permission to use it. And that's what the rest of the presentation is going to be about, is how do we go about that? Okay, so another little side quest here with things that are closely related to copyright. I wanted to spend some time on fair use because if you leave here with nothing else, fair use is not a get out of jail free card for a nonprofit. That's one thing I want to really drive home. It is something that's thrown around a lot, and so that's why I'm going to spend a little bit of time on it. So it is an exception. It's written into the statute that says that if a copyrighted work is being used for certain purposes, criticism, comment, reporting, teaching, scholarship, research, that's not infringement. We used to call this the journalism extension or exception, or the news exception, that you can use copyrighted subject matter for the purpose of reporting, um, or for purely educational purposes. That's what it's meant for. So what happens is, anytime you think something might be fair use, you have to apply these 4 factors that are on the bottom of the slide. And it's the other word I want you to understand here is this is mushy. This is oftentimes not clear cut. So the first one is like, okay, what's the nature and character of the use? Well, is it for profit versus is it for purely nonprofit educational purposes? This is mushy for 2 reasons. Oftentimes in faith-based nonprofit, um, it's not purely education. The services you're providing are not purely education. Sometimes you're providing services to people that they pay for, or that there's a government grant that pays for. So it's not purely nonprofit education. So there's the nature of the services that you're providing aren't always going to get you onto the nonprofit educational side. And this is only one factor. So even if it is, it's not a get out of jail free card for you. So the next one is the nature of the copyrighted work. Is it a factual work or is it a movie, a creative work? If it's a more factual work, then fair use is more likely to kick in. If it's a creative work, it's less likely to kick in. How much? And Frank, you were talking about that earlier in terms of how many pages can you reproduce? How much of the work are you using? Are you taking a clip from it? Or are you reproducing the entire movie? Or with the book, are you taking a page or a paragraph, or are you reproducing the entire book? That is another factor. The less you use, the more likely you're going to lean on the fair use side versus the infringement side. And then the last one is the effect upon the market for the value of the copyrighted work. If you're copying a book that you would otherwise have to pay for, then that gets you on the infringement side. If what you're doing has really no effect on the otherwise, the market value of the work, then it's going to lean more toward the fair use side. So wanted to go through that thoroughly. We're going to apply it a little later on. Next, another closely related is what we call the religious services exception. What I want you to leave from here is this is very narrow. This is particular types of work. So non-dramatic literary musical work. This generally isn't movies. So you can display that work if it falls into those categories in the course of services at a place of worship or other religious assembly. So it's either in a place of worship or it's a religious assembly. So if you're holding mass in a football stadium, this applies. But if you are having a training session for your staff in your offices, This does not apply. It's simply because you are a faith-based organization doesn't mean everything you do falls within this exemption. It's very narrow, very specific. So again, not a get out of jail free card. Last side quest before we get into some analysis here is public performance. I'm mentioning this because this is a pain in the butt and complicated. So public performance is any kind of a performance of a copyrighted work that's not in your private home. So anything you show, in the waiting room at your offices, honestly, even in private offices, in a business, at a place of worship, a Sunday school class, all of that is technically a public performance. So public performances of copyrighted works require special licenses. They require a public performance license. And the way this ends up working, and part of the reason I'm mentioning this is this often trips people up. You can go to your local cable operator and you can get a business subscription to cable TV. And you can get your cable channels, ESPN, a movie channel, and run those. And that provides, many people think that provides what you need. Well, it doesn't. You still have to have the public performance license. And the most efficient way to get those is through a blanket licensing organization. Now, there are others, there's BMI, but the two biggest ones are ASCAP and they're for music primarily, and then MPLC for movies. Those are the two organizations where you can go and you can say, I'd like a blanket license that covers, and what it does is all of these different distributors of either music or movies and television, they buy into these organizations and you can buy these blanket licenses. They aren't terribly expensive for nonprofits. So I don't want to scare you into thinking this is going to be a big bucks kind of thing. They generally have pretty reasonable pricing for nonprofits, but this is a tough area. And what's happening is many nonprofit businesses have become complacent with this because there hasn't been enforcement. The enforcement started, and for those of you who are old like me, I remember it back when the pay-per-view boxing was a big thing, and a bar would get a single residential license for the cable TV and buy the $59 pay-per-view license for the De La Hoya fight, and they would show it on 15 TVs in the bar. And what happened was these companies started sending spies into the bars and they'd take pictures. And because the commercial license for that bar would be $1,500. And so they would go in, they started enforcing that way. Now it's starting to trickle down that what they're doing is they're trying to enforce across the broader spectrum. Now they're going after hospitals. That's hospital networks are their target right now. Because many hospitals run cable TV in patient rooms. They'll run televisions in their waiting rooms, and they think because they have a commercial license they can do that. Well, most of those commercial licenses don't give you the public performance rights, so you still have to go back to ASCAP for music or MPLC for movies and television. So hitting this because it's an area where folks have been lulled into complacency because there has not been enforcement. The reality is, if you run a relatively small nonprofit and you're showing, television in your waiting room, the likelihood that someone's, one of their little spies is going to come in there and take a picture is somewhat low. So there's still a risk issue here, but just be aware that there is a risk. And the larger your organization is, and the more offices you have, and the more public it is, the more likely there is to be an issue. For the most part, if they catch you, they're going to give you an opportunity to purchase a license. They're not going to come after you right out of the gate for a big damages number. All right. I lied. Last slide. So, right of publicity is the one that's tightly tied and that's why I'm mentioning it. It's not technically an IP right, but this is think NIL in sports now, which is huge. Everyone has the right to control the use of their name and likeness for commercial or exploitive purposes. So technically, if you are showing someone's face in a photo at a charity event, you are exploiting that, you're using them to support your organization. So technically, you need their permission to do that. Now, as a practical matter, are people going to object? No, for the most part, because they're there to support your organization. They're happy to have, pictures taken, and it's not something that in general that they're going to have a problem with. From a best practices perspective, you can cook the name, image, and likeness permissions into your employment agreements, into your independent contractor agreements. You can put a notice on your tickets, so when people buy tickets for a fundraising event, that they are giving you permission to use their name and likeness. You can do that. That's something proactive. And then if you have a specific instance, it's as simple as just sending them an email and saying, hey, can I do this? And they email you back and they say, sure, that's fine. You don't have to have a signed contract as long as you've got that email that says, yeah, I give you permission, go ahead. So that's how you manage that one. For the most part, this isn't going to be a big deal. And if someone objects, the remedy is you simply take the image down. You're not running a $10 million Nike shoe campaign off of these folks, which that would be different. All right. So how do we manage copyrights? Same. I recommend that you do a copyright audit if you haven't, just to discover, okay, what types of copyrighted works are you using? What procedures do you have to make sure that you have the proper rights? So I've tried to create as simple a checklist as I can. So, look at each category of, different types of copyrighted works that you're using in your organization on a frequent basis. The ones that you're using frequently have procedures, have something written down so the people that work with you understand how to go about this. But then for each one, you just go down the list. Do we own it? Is this a photograph that one of our employees took? So we own it. So let's say an employee with an IP clause in his or her contract, or an employee within the scope of his or her employment took the photo. Yep, we've got rights. Okay, that's easy. Now we've got the rights, so we can do with it what we want. Subject to the publicity rights, which we'll get there. So what if we don't own it? Well, do we have the religious services exception? Probably not. It's narrow, but we want to check that box. Is it fair use? Well, if you have a clear-cut case, if it's simply reporting of news, or it's purely educational, then you might be able to get into fair use. But like I said, it's mushy. So then let's say you don't own it. It's not religious services exception. It's not clearly fair use. Well, now you got to nail down permission, that you've got rights to do this. And you got to make sure, looking back at that public performance slide, you got to make sure you have the correct license. And then if a person's name or likeness is in an image or is being used, you want to make sure you've secured that right of publicity, or that you're comfortable that the person isn't going to object. And that's not going to apply in every instance. So, all right, so let's do some examples. So you're going to use a third-party image on your website or your social media page. So let's run the playbook. Do you own it? Let's say you don't. Let's say this is an image. So one of your coworkers goes on Google Images and finds a nice image they like. This has burned a number of our clients, both in the profit and nonprofit world. You cannot assume that because an image is just sitting there on the internet that you are free to use it. If you need to go out and get a stock image of some kind, there are websites where you can purchase very low-cost licenses to get stock images, or some of them are free. The quality isn't as good, but you can do that. Or it's an image. Make sure you use your own images. Go out and have some of your people take a photo. But if it's not your image, then, and you don't have ownership rights, well, you look at the two exceptions, the religious services exceptions. Is it fair use? If you're using it on your website to simply advertise your services, it's probably not going to be fair use. Um, and so then, do you have rights to it? So, and then the do you have rights is, do you have a license to, to a stock images site? Is it something that you verified is a free image that's freely available? That's the process you have to go through. And then you've got people's faces here. So the publicity right comes in if you're concerned about that. And that's, if it's a stock image, it's safe to assume that they've already cleared that. Um, but if you are taking a photo of people randomly on the street, technically they could object if their faces appear in an image. Are they likely to? Probably not. But I don't want you to be surprised if someone comes to you and objects someday. You may, if they do object, you got to take it down. Or you can blur out their face if you just want to be funny about it. So that's the first one. Let's see here. There we go. Um, Providing media in a waiting room. So cable TV, movies, or music in a waiting room. This is another real common one. Do you own, run the playbook? Do you own it? Probably not, because you're probably running, cable TV service or a DVD or Netflix, or you're running music in the background. Is it a religious services exception? Probably not, because it's not a worship service. It's a waiting room. It's a place where people are waiting to receive services. Is it fair use? Probably not. Is it for educational purposes? If it's just a waiting room, that's not really clearly educational services. It's either creative works, so that's more on the infringement side. Are you running you're running the television show all the way through? Well, okay, so that runs on amount, how much of it are you using? That runs on the infringement side. And these are things that people pay for, they have subscriptions for. So probably not going to be fair use. So then you come into, and we did touch on this a little while ago with the public performance, you're probably going to have a a commercial license from your local cable TV provider and a blanket license from one of the blanket license providers in order to do this the right way. Um, can you do it and get away with it in a small environment? Maybe, but there is a risk there. And if you get called to the carpet on it, it's not a scam. This is a real thing because it is a public performance. So how you deal with this is, and you might choose not to have a television in your waiting area, which I know is hard, because if you're serving families, you want to keep the kids entertained, give them Legos. There's a consequence if there's a potential risk and a potential consequence if you're going to have a television running in a waiting room without a commercial license and without a blanket license. So you're going to have to decide whether that risk is worth it, or if you want to go out and see what that costs to get the blanket license. All right. So reproducing excerpts from books in a newsletter, a sort of common one. This one, fair use, is going to be kind of front and center. Religious services exception doesn't hit. You don't own the copyrighted material that you're putting in here. Let's assume that. So it's going to come down to fair use. How much of it are you reproducing? Are you reproducing a paragraph from a book, or are you reproducing an entire chapter? The more you use, the more at risk you are. How is it being used? Are you doing a book review? If you're reviewing the book and talking about and critiquing it, that starts to get very squarely into fair use. So how are you using it? So a big part of this example is illustrating why this is mushy. Because you can take the same chapter of a book or a page from a book, put it in a newsletter, and depending on how you're using it, that can sort of weigh one way or another in terms of whether it's clearly fair use, or maybe there's a little bit of risk there. So if you're posting images from a fundraising event on social media, let's assume that one of your people is taking the photo. So what do we have to pay attention to? So now you own it. Well, we can't forget about the right of publicity. How How concerned are you about that? Okay, the attendees at your fundraiser are unlikely to object. But if you're going to do a lot of this and you have a large organization, it might be worth considering putting, I'll call it a disclaimer, but a notice when people buy tickets that by buying a ticket and attending the event, they are consenting to having their image used. Um, you'll see these a lot at sporting events because they want the right to use fan images on their social media pages and things. If you turn your ticket, a lot of it's digital now, but if you have a paper ticket and you turn it over, it's going to have a little clause, a little sentence in there that says that you're giving them the right to use your name and image and likeness in association with reporting and publicizing the sporting event.